Animals cannot be punished. Inanimate objects cannot be punished. But in the olden days, even the animals or inanimate objects were punished by the state. Animals. Hello friends. Today we shall discuss important elements of crime. What are the different elements which constitute the complete crime? In previous videos, we discussed the nature of crime, definition of crime, and relationship between law and religion. In today's video, we shall discuss different elements of crime. What are those elements? Those elements, there are 4 elements which constitute the crime. Those 4 elements are very important. If any one of them is lacking, the crime will not constitute or crime will not be completed. For the completion of the crime, there should be all the 4 elements at a time. First element is human being. Second one is mens rea. Third one is actus reus. Fourth one is injury. What is the first one? That is the human being. Human being is very important element for the commission of crime. It means there should be human being who is going to commit the crime. Means wrongdoer should be the human being, and the person against whom this offense or this crime is being done should also be human being. Meaning thereby is that the animals, in today's scenario, the animals are not made liable for punishments for the commission of the crime, or inanimate objects cannot be made liable for the commission of the crimes because they don't have any mens rea or intent. We shall discuss the element of mens rea after some time, but before this we want to explain what is the need of the main important element of crime, which is human being. Means for the in the present society, in the present scenario, according to the present law, human being can be the wrongdoer only, not animals. Animals cannot be punished. Inanimate objects cannot be punished. But in the olden days, even the animals or inanimate objects were punished by the state. It is the feeling of human being in the society that if any wrong is done by anything, by any animal or by any inanimate object or human being, they should be punished. Means feeling of retribution, feeling of vengeance was there in the olden days. And at that time, besides human being, animals and inanimate objects were punished by the state or by the individual or by the society. So individual, society and the state all are having power to punish the wrongdoer. In the olden days, individual was having power, capacity to punish on his personal capacity to punish the wrongdoer. Later on, the work of punishing transferred to the society. The work of punishing the wrongdoer was with the individual in beginning. Later on, it was transferred to the society. Society was conferred with the responsibility to punish the wrongdoer. And at that time, for the individual, society has taken the steps for punishing the wrongdoer. There is a book, Curiosity of Times. The book Curiosity of Times is a very important book, which was written by Baring Gold. And this book contains all these facts. This book clarifies or verifies the facts that the animals and inanimate objects were also punished in the past or in the olden days. This is the object of the criminal law, that only the human beings will be punished in the present time, not the inanimate objects or the animals. If any offense or any crime is committed or done by any animal, the owner of the animal will be punished for not taking proper care of its animal. Animals are not the subject of punishment these days. In the past, the animals and inanimate objects were the subjects of punishment for commission of the crime. But in the present day, only the human beings are the subjects of the crime. Offense or crime should be committed by one human being against another human being. The second, and which is very important element of crime, that is mens rea. There are two important maxims which are necessary to be understood. First maxim is Actus non facit reum nisi mensitria. Second one is Actus me invito factus non est mens actus. These two Latin maxims are very important for understanding the second element for the constitution of the crime. Actus non facit reum nisi mensitria explains that the act and intent both must concur. If act is done without an intent, the crime is not completed. Crime will be completed only completion of both intent and act. Without intention, act will not be converted into an offense or crime. Offense should contain both at a time. And second maxim, Actus me invito factus non est mens actus, denotes that the act should be willed act and criminal intent. Both should be present. Act should be willed act, not only act, willed act. If act is done under compulsion or under threat, then the act is not willed act and the crime cannot be the complete offense. Actus mensia is very important, and mensia is very important for the commission of the crime, and it is very important because the liability or punishment depends on the mens rea also. For example, if we take an example of mens rea, that is, if a man kills one person with a knife or by administering poison in the body, that person will be punished for imprisonment of life or death penalty. If another person kills 20 persons just because of accident, there is brake failure and 20 persons were killed because of that brake failure, and this is example of accident, and the punishment will be only 2 years. The punishment will be for 2 years because in the matter of accident there is no mens rea, no guilty mind. This is accident only. But in the previous matter, the guilty mind is there, mens rea is there, positive guilty mind is there. The person will be punished for the death penalty or imprisonment for life. Means this is very important element for making or for committing the crime. The intent and the act both must concur to constitute the crime. The actus non facit reum nisi mensitria. This Latin maxim says that the act itself does not make a man guilty unless his intentions were so. Where the criminal intent necessary to constitute the crime is wanting, there is no criminal responsibility unless the offense is expressly or by necessary implication punishable without reference to the wrongdoer. English law started with a rule of strict liability. A man must in almost every case be deemed to have intended to do what he had done. In the past, in England, there was no clear distinction between crime and tort, and the punishment was money payment by way of compensation to the person wrong done. Mental attitude of the wrongdoer was an irrelevant consideration. Later on, bodily punishment started and the notion of criminal intent came into existence, and the punishment started to be given on the basis of the criminal intent to the wrongdoer. Later, human being and evil intent are not enough to constitute the crime, as one cannot know intentions of a man. The criminal, to be punishable, must become manifest in some voluntary act or omission. According to Kenny, actus reus is such result of human conduct as the law seeks to prevent. The thought of a man is not triable. The act done or omitted must be forbidden or commanded by some law. According to Reus, Actus Reus is the physical result of human conduct. When the criminal policy regards any act sufficiently harmful to the society, then it is prohibited on the pain of punishments. A man is punished for his own conduct and not for that of others. The law penalizes the acts as contrasted with bodily states and involuntary behavior. There are 4 situations in which action is necessary. Number 1, that lies concerned with positive conduct as opposed to just inactivity. Number 2, law prohibits acts as opposed to thoughts or intentions. The act includes illegal omissions also. A man is held liable if some duty is cast upon him and he omits to discharge that duty. And a person is said to be legally bound to do whatever it is illegal in him to omit. Section 43 of the Indian Penal Code or Section 215 of the Bharatiya Nyaya Sanhita lays down that the word illegal is applicable to everything which is an offense or which is prohibited by law or which furnishes a ground for civil action. Now, we shall take some examples of an act or omission. Example number 1. A person A was walking along the side of a road, a deserted road, at night in winter season. There on the side of the road, he saw an abandoned child, newborn infant, and he did not take any step to protect that child from the winter. Later on, another person B went along the side of that road, and in the same fashion, he did not take any step to protect that child. In this example, neither A nor B is liable for the death of the child because both are not duty bound. They are not conferred with any duty to protect the child. Hence, both of them are not responsible or liable for the death of the infant. Another example, suppose there is A and B. A is husband and B is wife. And there is a bitter quarrel between the husband and wife A and B. B threatened the husband A to commit suicide. And all of a sudden, wife B went to a well and jumped into the well and died. Here, in this example, husband A is not liable for the death of wife B because there is no act or illegal omission on the part of the husband A. Hence, the husband is not liable for the death of the wife B. Now, we shall take another examples of an act or omission. If a person allows his wife and young children to die of starvation, here in this example, that person owes a duty, legal duty, to maintain his wife and young children. And if death is caused, that person is liable for the death of the wife and young children. In another example, if a person does not make any attempt to protect a person M who is swimming in the river and he dies, and many other persons are also standing on the side of the river, even some of them are good swimmer, but they don't make any attempt to protect the life of that person M who is drowning in the river. Here, inactivity of any person who are standing on the side of the river is not liable for the cause of the death, because they don't have any duty towards the person who is drowning in the river. In another example, in which a person pushes a person A, suppose the person is A, pushes the other person B in the river, and because of that push, B is died. Here A is liable, because here in this example, A is the obvious person who is the cause for the death. Hence, A is liable for the death of the B, and act of the B is responsible or liable for the death of the B. Hence, A will be prosecuted for the death or for the murder of B. If we compare two examples, example of the drowning person and pushing by A to B into the river. In the drowning matter, there is no person on whom blame can be imposed or blame can be put. But in the matter of pushing B into the river, there is obvious person on which blame can be imposed, and the person who has pushed the B will be liable for the death. And if we compare the drowning with the starvation by the husband to the young children and wife, in this example, there is inactivity of the person who are standing on the side of the river. And this is the example of inactivity of the person standing on the river. And in the matter of starvation, there is illegal omission on the part of the husband. And that is the example of illegal omission. And here is the inactivity. And the illegal omission is a crime. Illegal omission is a crime in the law of crime. And if we talk about the bystanders, there is inactivity on the part of the bystanders, or there is refusal to rescue the drowning person. Here, that person is liable for moral condemnation of only, but there is no crime on the part of the bystanders. When we discuss the situations of illegal omissions and inactivity, law and morals move in different directions. With the growth of humanitarian ideas, there is expansion of duty to others, and the cases of inactivity may be included in the list of illegal omissions. These cases of inactivity are not approved by the civilized societies. The last element of crime is injury. This expression injury has been defined in section 44 of the IPC or section 214 of the Bharatiya Nyaya Sanhita. The expression injury denotes any harm whatsoever illegally caused to any person in body, mind, property, or reputation. Injury must be caused illegally to any person or body of individuals or society at large. Thank you so much for watching this video on the very important topic, elements of crime. Please don't forget to like and subscribe my YouTube channel, Law Made Easy with Dr. Rajesh, Advocate. Thank you so much.